All right, and we do have Jimmy Ray Howard, I believe. Good morning, Mr. Howard. Can you hear us?
I object. It sounds like court's trying to subject me to your jurisdiction. Is this a court of record?
So, Mr. Howard, this is 86 District Court. It's the time and place for an arraignment in case 26-5132 SM. You're zooming in with us this morning. Also zooming with us is Defense Attorney Roberts. She comes to us through the Indigent Defense Council, and she's here to assist with the arraignment process. We also have Assistant Prosecutor Ms. Wandmacher zooming in with us.
I never gave consent to have any attorney appointed to speak for me.
She's not
Anyway,
appointed to speak with you, sir. She's sitting in with us. She is here to assist if you are interested in speaking with her, but you certainly do not have to.
okay, well, this is a court of record, correct?
Yes.
Okay, one to UCC 1-103 and UCC 1-308. I reserve all my rights at all times and I waive none ever. I'm here by special appearance only, not generally, under threat, duress, or coercion as authorized representative in this tax court.
Okay, so sir, you're reading from the Uniform Commercial Code, which has nothing to do with criminal law. You also just mentioned tax code. So I don't.
Right here is where things start to unravel. The defendant is citing the Uniform Commercial Code and federal statutes like they apply universally. But in reality, those laws govern commercial transactions, not criminal charges like driving without a license or insurance. This is a common misunderstanding we see in courtrooms, where individuals believe certain magic phrases can override jurisdiction. The judge immediately pushes back, clarifying that none of those references apply to this case. So now the real question becomes, does the defendant genuinely misunderstand the law, or is this a deliberate strategy to delay proceedings? And more importantly, how do you think this approach will play out as the case moves forward?
know if you don't want my assistance, that's fine, but everything you just read has nothing to do with what you're here for this morning.
Uh, I move the court to take judicial notice of 28 USC.
Okay,
3,
Mr. Howard,
2004.
I need you to stop talking. This is the time and place for an arraignment on an alleged operating without security, operating without a license, operating an unregistered vehicle. And I don't want any games. I just want to move on with this. So let's see here. I also need you to report to the Antrim County Jail to get your fingerprints taken. So we're going to have to work that into the schedule. But as far as the allegations in this complaint, Mr. Howard, would you like to stand mute?
I'd like to move for dismissal, no process,
Okay,
lack of jurisdiction.
that's not something that we would do here at the arraignment. So what I can do is ask the court to enter a not guilty plea, that you stand mute, and we can set it for a pretrial. Do you want to be screened for a court-appointed attorney, or would you like to operate in pro per and represent yourself?
I'm going to represent myself.
Very good. I have a mailing address of 1950 Alden Highway. Is that correct?
That is correct.
All right. Do you have an email you'd like to list with the court?
No, ma'am. I want to put on the record, I do not consent to any of this.
Okay, duly noted. The next step in the process is going to be a pretrial conference on April 15th at 8 a.m. That will be in person at the courthouse here in Bel Air, and we'll mail another notice to appear to you. You weren't arrested, but I do have to set a bond. I'm going to set it at a $500 personal recognizance bond. So you don't have to post any money today, but I would ask that you not operate any motor vehicles without proper license, registration, and insurance through the state of Michigan, and that you remain respectful of all court staff, service and care providers, and obey all lawful commands. I appreciate you being here this morning, and please don't forget to get your fingerprints taken. If you'd like, you can do that this afternoon, or if you want to make one trip and do that on the 15th, we could accommodate that as well. Thank you for being here. And if you don't have anything further, you are free to leave the meeting.
In the end, what we've seen here is a textbook arraignment where the court stays firmly on track despite repeated jurisdictional challenges. The judge proceeds correctly, entering a not guilty plea, setting bond, and scheduling the next hearing, while making it clear that legal arguments must be raised at the proper stage, not during arraignment. The defendant's decision to represent himself adds another layer of risk, especially given the confusion around applicable laws. Moving forward, the pretrial will be critical in determining whether these arguments evolve or fall apart completely. If you found this case as shocking as we did, make sure to hit that like button, share your thoughts in the comments, and don't forget to subscribe for more jaw-dropping courtroom breakdowns.